Today, the Supreme Court heard oral arguments in the critical ATF case, which is Cargill. Now they will rule on whether or not bump stocks in similar devices are in fact machine guns under the NFA and GCA. So let's talk about what happened during these arguments. Also want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all viewers are actually not subscribed to the channel. So if you want to support the channel, if you want this type of information to get out, this type of two-way content to get out to more people, please consider subscribing to the channel. That really does help the channel to grow and to get this information out to more people. As I mentioned in the intro, in this video, we're going to be talking about and breaking down a huge Second Amendment case, a huge ATF overreach case, an interpretation case that is now up for Supreme Court review and was heard by the Supreme Court today. The case is a challenge to the ATF's regulation of bump stocks as machine guns. As many of you know, the ATF has been redefining various items and making them subject to the NFA and GCA's restrictions. One of the first items that they did that with was bump stocks, and the ATF decided arbitrarily to go back on years of guidance, years of letters that were sent out, and suddenly say now magically bump stocks are in fact machine guns and therefore subject to federal regulations. Now, these new ATF restrictions were in fact challenged in this case, which is Cargill versus the ATF. But now this case is in the hands of the United States Supreme Court, who heard oral arguments on this issue today. The big question of this case was first, whether bump stocks meet the definition of a machine gun under the GCA and NFA, and then second, is there an ambiguity or dispute on what the term machine gun actually means? And then ultimately, what type of deference should the ATF be given if there was an ambiguity? One of the important aspects of this challenge was whether or not Chevron deference should be given to the ATF in relation to their final rule on bump stocks, or whether a different rule, something like the rule of lenity, should be used and would ultimately direct courts to rule in a way that is more favorable to us, the people, not the ATF. And a lot of this, again, this second layer of analysis about deference is really determined on the finding of ambiguity. Now, in this Cargill case, in a 13-3 decision, the en banc panel in the Fifth Circuit found that the ATF overstepped its authority in regulating bump stocks as machine guns under the GCA. The Fifth Circuit stated that a plain reading of the statutory language, paired with a close consideration of the mechanics of a semi-automatic firearm, reveals that a bump stock is excluded from the technical definition of machine gun set forth in the GCA and NFA. In that decision, the Fifth Circuit en banc panel clearly identified that the definition of a machine gun in the GCA and NFA does not include items like bump stocks. And then they went on to say, even if those terms were considered ambiguous or vague on that type of issue of whether or not they're included, the court said that the rule of lenity would direct them to interpret it in a favor of us and ultimately find that bump stocks are not machine guns. And they said that if Congress or the ATF wants the definition in the GCA to include these types of items, well, then it's on Congress to change the statute. But the ATF does not have the power to do that on their own. So that was a huge win and resulted now in the ATF going up to the Supreme Court and asking for Supreme Court review, and that review happened today. Oral arguments took place in front of the Supreme Court today. So ultimately, the major contested issue is whether the definition of machine gun in the GCA includes items like bump stocks. The definition of a machine gun can be found in 26 USC section 5845 subsection B. The term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. So the Supreme Court heard oral arguments today on whether or not bump stocks meet that definition and whether or not the ATF's regulation of bump stocks goes beyond that statutory language. Again, they have to look at these statutory terms and that language there about what a machine gun is. Now, my first impressions of the arguments is I'm not entirely confident that this will come out in our favor. At best right now, I think we could maybe, skate by with a 5-4 vote, but it could also be a 5-4 vote in favor of the ATF. In some of the questions, we're definitely leaning in the favor of the ATF. So I want to make that very clear. That is because most of the arguments focused on whether or not bump stocks, cause a firearm to shoot automatically more than one shot by a single function of the trigger. Most of the arguments kind of got hung up on the first level of analysis, which is what is the language and what is included in that language. The Fifth Circuit en banc panel ruled that, these types of items did not fall within that language, but now the Supreme Court is trying to determine that on their own. The pro-2A side argued that the mechanism of a semi-automatic rifle with a bump stock attached to it still only shoots one round by a single function of the trigger. The argument is that a bump stock does not change the internal operation of a trigger at all, and therefore it falls outside that definition of a machine gun. However, the ATF argues on their side that the term function of a trigger really is just simply another word for pull of the trigger. So they are trying to change the language from function of the trigger into the pull of a trigger. The ATF argues to the Supreme Court that Congress, when they passed this law, really intended more to regulate firearms with high rates of fire, and that at the time of writing the statute, function of a trigger and pull of a trigger were kind of used interchangeably, and therefore they say that they mean the same thing. This is critical to their argument because what the ATF wants to do is shift the analysis away from what the trigger is doing mechanically, kind of what the mechanism is, and instead they want to focus on the shooter themselves. They want to focus on what type of input a shooter has on the firearm. The ATF argues that the GCA's language is focused on what input the shooter places on the firearm and what ultimately result in a higher rate of fire. In contrast, the pro-2A side, our side, argues that no, the plain statutory text said single function of the trigger, not pull of the trigger. But Congress decided not to say single pull of the trigger. They said single function of the trigger. And ultimately, they also argued that could be because what ultimately could have happened if they said single pull of the trigger, that means a bunch of other firearms like push button full auto firearms would not have been regulated at that time. And Congress knew that, so they said single function of the trigger. One of the other points made by the pro-2A side during these arguments was essentially that people don't function. The textual language says function of the trigger. The ATF is trying to insert, human operation into this when really the GCA's language is more focused on the, mechanical operation of the firearm. It's not focused on the individual themselves. I think if you take anything away from the arguments today, it's that there was a dispute and a lot of questions which really focused more on the first layer of analysis. It is a dispute about textualism. It's a dispute about what terms mean and what they cover. And that really is kind of that first level of analysis, before you move on to other things like Chevron deference and the rule of lenity. There were some questions by justices like Gorsuch about the ATF's prior interpretations and how they've changed their position back and forth and what does that mean as far as ambiguity and uncertainty and how maybe the court should rule in this case. There were concerns by many of the justices about the ATF's prior guidance and how maybe could now open up some people to being prosecuted because of the changes. Now, the ATF tried to brush off those concerns by saying that the prior guidance letters were not full legal reviews, but after that Las Vegas incident, they did kind of a full legal analysis and review and came to their new determination. There were points where justices like Alito, Thomas, and even Roberts tried to distinguish how a bump stock and the operation of a semi-automatic firearm with a bump stock, how it is much different from, just a traditional full auto firearm, and how the bump stock itself does not modify the trigger mechanism or the internals of a rifle at all. Personally, it seemed to me that Alito probably had the best grasp on the mechanics of these firearms, what a bump stock did, full autos versus traditional semi-automatics. It seemed like Alito knew the most, and hopefully that's going to help some of the other judges because it seemed like a lot of the other justices were getting really bogged down into the whole mechanism question. It seemed like they did not understand what was really going on. Now, I will say once again during these arguments, I was very concerned about some of the line of questions that Justice Barrett put forward. She said that she watched a lot of videos on bump stocks, and she said that she is ultimately sympathetic with the ATF's position. Now, she did say at one point that if Congress wanted to say pull the trigger, then why didn't they include that? And, why doesn't Congress just change that now? So some of the things that Justice Barrett brought up, some of the questions that she brought still bring me pause. It seemed like, again, she stated very expressly that she's sympathetic with the ATF and what they're trying to do. Now, ultimately, how that will play out and how she votes is yet to be seen. But again, we've had some concerns about Justice Barrett. So again, some red flags in her questioning. And I think this is really going to come down to whether some of the conservative judges stay true to the textualist ideas. I'm hopeful that the conservatives stay true to the textual analysis and rule only along those lines. And I think if they do that, we win. And then even if there's some sort of ambiguity that's found, I think if you look at Chevron and if you look at things like the rule of lenity, we win as well. So again, in my mind, I think it's going to be kind of a flip of the coin. I think it could go 5-4 in our favor. I think it could go 5-4 even in the ATF's favor. And I also wouldn't even be surprised if it went 6-3 against us. So just kind of my general take and impressions after listening to the arguments. If you guys want to listen to them for yourselves, I will leave a link down below in the pinned comment where you can listen. Again, huge case, broad-reaching implications, and I just don't get the warm and fuzzy feeling after listening to these arguments. But as always, if you guys like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and don't forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.